All right, welcome everybody. I'm Mark Lemley. Welcome to our program on patents and the First Amendment. This is part of a series that we are putting together jointly with Mozilla on intellectual property and the First Amendment. And this is maybe in some sense the oddest or most surprising one. There are some well-established issues that connect trademarks and the First Amendment, in fact, including a Supreme Court case to be decided this term, copyright and the First Amendment, even if we like to pretend that conflict doesn't exist, the right of publicity. But patent seems a little bit of a stranger to this question. Nonetheless, I think a couple of significant issues have brought it to the fore in the last few years. One is the Myriad case, challenge to the patentability of genes, brought in part by the ACLU and brought in part on a First Amendment theory. The other more recently is Judge Mayer's concurrence in Intellectual Ventures versus Symantec, in which he wrote that, quote, essential First Amendment freedoms are abridged when the Patent and Trademark Office is permitted to balkanize the internet, granting patent owners the right to exact heavy taxes on widely used conduits for online expression. We have a really interesting panel here to talk about whether or not patent law should be a First Amendment issue and under what circumstances. I'm going to introduce our moderator, Elvin Lee, who is product counsel at Mozilla, who handles intellectual property and litigation, among other more interesting things like video games. And he's going to introduce our panel and take it away.
Well, thank you, first of all, to Stanford Law School for hosting us here today. This is a topic that's very exciting to me, and so I'm particularly excited to have our panelists here to discuss. So I'm going to quickly, briefly introduce them, and thank you, of course, Mark, for the wonderful introduction. So to my left, I've got Dan Burke, who's a professor of law at UC Irvine, and besides being a leading scholar on intellectual property, and he is also the author of a article called Patenting Speech from back in 2000. As Mark alluded to, that in some ways people look at patents and speech and the First Amendment and they think, oh, that's kind of an odd pairing. But I think that kind of goes to show how that is in the sense that there isn't as much legal scholarship on the subject. But the other thing that Professor Burke has been working on quite a bit is interdisciplinary approaches to intellectual property law, and of course this certainly, I think, fits the bill here. To his left, we have Wendy Seltzer, who's a strategy lead and policy counsel at the World Wide Web Consortium, also known as the W3C. That's one of the leading standard bodies that help develop the standards that power the World Wide Web, and disclaimer of which Mozilla is, of course, a member. And at the W3C, she regularly deals with patent matters as they arise in the standard setting context from time to time. She also is the author of an article which was cited by Judge Mayer in his concurrence regarding in his concurring opinion in Intellectual Ventures that Mark mentioned. In addition, she has also helped to start the Chilling Effects Clearinghouse, which of course was a website and project designated to study legal threats to online speech and activity on the internet. And then to her left, we've got Bob Sachs, who's a partner at Fenwick & West, and besides representing a lot of high technology clients, he's also a primary author on the Bilski blog and known as kind of an expert on subject matter eligibility, which of course is a subject that is very important and intricately tied to the First Amendment aspects of patent law that we're going to be discussing today. And then joining us remotely, last but not least, is Sandra Park. She is a staff attorney with the ACLU Women's Project and part of the team that led the challenge to the Myriad case that Mark mentioned back in 2013 when the Supreme Court ruled on the patentability of genetic material there. So that being said, we're going to go ahead and dive right into it, but a few kind of quick matters before we do. There are cards at the front for those who are in the live audience. If you have questions that you don't want to forget them, please feel free to write them down and pass them up. Shez in the back there will be going around and collecting them from time to time, and she'll funnel them up to the front. We'll try to get to them in the course of the conversation. There are also mics, and we'll try to save some time at the end for questions that somehow just didn't fit into the conversation or that we didn't get to. but please feel free to take advantage of the note cards. Also, I believe Neffy, who's also in the back there, is going to be checking. For those of you on the live stream, he'll be kind of trying to collect any questions that are percolating up from that chat, and he'll also be trying to pass those to me as it happens. So without further ado, I'm excited to talk about patents in the First Amendment. So as I mentioned, Professor Burke, your article back from 2000, Patenting Speech, seems like a long...
Which Judge Mayer didn't cite.
Judge Mayer didn't cite, surprisingly. I know, but everyone else does cite when it comes to this topic. And as I mentioned, this is a topic that's very interesting to me, but when I started looking into it, I was hard-pressed to find a lot of literature. And obviously, your article was one of the notable exceptions. And the article definitely went into a lot of the different issues that might come up in the context of patents and free speech, patents and expression, patents and software as speech. Can you kind of give us a little bit of your take about, A, why did you write the article, and what have you seen have been the developments, in the state of patents and free speech in the 17 years since? Well, long overdue for a revisit.
Yeah, well, I'm very excited to be here, and thank you for organizing, Elvin, and thanks to Mark Lemley and to Stanford for hosting, because this is a great conversation, and said, I think long overdue. To answer your question, I think maybe the best answer I can give is to try and frame the issue or frame the discussion. So like most First Amendment questions, there's a range or a spectrum, right? I mean, and you could be on one end of the spectrum, which I think is what Judge Mayer was concerned about, and you could have inventions that somehow promote or involve speech, right? I could invent a new type of printing press, or I could invent a new word processor, and that has implications for speech. Probably that's not a big problem, because unless you're at the point where there's sort of an antitrust issue, that's the only way to engage in a particular kind of speech, having exclusive rights or having governmental regulation there may not be a big issue. And that's something that I think the panel will want to talk about. And in particular, if it is one of the only ways to engage in a certain kind of speech, a particular invention, we might want to think about, for example, the spectrum cases, right? The Red Lion line of cases that talks about governmental management of those kinds of resources. But my guess is that you will probably get from the Supreme Court on that kind of a question the same sort of answer that we've gotten in the copyright area, which is, well, yes, copyright certainly restricts some kinds of speech and regulates speech, but the idea is to get people to invest in speech. So in the long run, copyright's good for speech, even if in the short run you get some restrictions. So patents might be the same way. You might get more printing presses or more word processors. On the other end of the spectrum, you have patents that directly regulate speech, right? And this, in fact, is what the ACLU Patent Policy Committee was originally concerned about before they sort of got off onto the pursuing gene patents in the Myriad case. But Chris Hansen and other people recognized that there were patents issuing that covered a method of plotting a novel, for example, or methods of advertising, right? It sort of directly regulated speech. And that's that's somewhat more problematic, right, than the device type of patent. And then in the mushy middle, you've got software, which kind of partakes of both of those, right? So we've got a line of cases that I talk about in the article, mostly having to do with encryption export controls that tell us that software is expressive and it is protected by the First Amendment, although it gets a lower level of scrutiny, the O'Brien scrutiny, because it's both expressive and it's a device. Right? And this has been a problem in software copyright for a long time, right? Which is what's expression and what's functional. And so you mentioned the dissent or the concurrence by Judge Mayer. I think actually the place you look first, or we should look first, is a little bit further back, right? Robert will be familiar with the old case In re Allopat, where Judge Archer pointed out in the context of software patenting. You know, if you encode expression, and the examples he gave were up in a piano roll, right? You know, holes punched in a piano roll, or in a DVD or a CD. You have a new object, right? You have a new artifact that under Section 102 is novel, right? It wouldn't exist in the prior art, and depending on how you formulate Section 103 scrutiny, might also be non-obvious. So it might be patentable, but you are definitely covering expression or covering speech with that patent, and that's really the problem, right? We don't have good tools for sussing out where's the expression versus where's the artifact, and figuring out where we are in that spectrum. So that's what I tried to point out in the article, and that's I'm not sure that we've solved that problem yet. I think that's what Judge Mayer was talking about in his opinion.
Okay. You know, it's interesting that you mentioned Judge Mayer dissent or concurrence.
Yeah.
And some people might say that, you know, it might as well be called either which way.
Right.
Something I found very interesting was kind of looking at the landscape and seeing what everyone's reactions were to Judge Mayer's concurrence at the time. Now, you obviously looking back at Myriad, and even before that, Bilski, the ACLU had quote unquote injected the First Amendment issue into the dialogue on patents, but you know, the court's opinions there did not really touch on it, right? It was not picked up, but it was introduced, and so it was certainly, you know, not the first time it was mentioned, but some of the people reacting and some of the commentators were very, very harsh on Judge Mayer immediately following, you know, the issuing of his concurring opinion. Some people even called for him to resign. Do you have a reaction to that? Like, is it quite as extreme as some of these people are making it out to be?
Well, you know, Robert may have more to say about this because I'm sure he gets these kinds of reactions on his blog, right? You know, this is what is a great surprise to the patent community. The copyright community has been dealing with for the last 30 or 40 years. As I mentioned, you know, we've had this question as to, you know, software being expressive and also being covered by copyright and also sometimes being functional, and which, you know, what are we talking about at any given time? It was only a matter of time before that appeared in the patent space, right? It sort of had to, and I don't think that very many people understood that or recognized it, and it was kind of a shock when it happened. So I think that's the response that I've seen as a response from detecting to Judge Mayer pointing out what, you know, to some people was obvious was going to happen.
Also, I would say the opinion, to quote the famous physicist Pauli, is not even wrong. It is so far removed from a coherent explanation of software and the First Amendment. It's a breathtaking lack of a familiarity with the history of technology. So to say that one should, you know, kind of the last question, you know, should he resign? He certainly should recuse himself from any 101 case. He has made it absolutely clear he will never find patent-eligible subject matter in any software patent, regardless of the facts and regardless of the law, most importantly. I don't know what draft of the Alice opinion he read, but the published opinion did not say anything about the death of software. The First Amendment concerns associated with patent could be avoided if this court were willing to acknowledge that Alice sounded the death knell for software patents. In the oral argument, the Solicitor General, Justice Sotomayor, asked, do we think we have to reach the patentability of software to answer this case? And the Solicitor General says no. They didn't rule on the patent eligibility of software. They quite clearly avoided ruling on it. Why? Because they didn't believe there was any software in the case. They were told that there was no software in the case, that was not the significant issue. So he's not following the law, and he's quite clearly saying he will not follow the law. So yes, I think he ought to recuse himself. Whether he should resign, he can rule on Veterans Affairs and other matters. That's perfectly fine. I'm sure he's capable of that.
A lot of Veterans Affairs cases at the Federal Circuit, no doubt.
Yeah. But as to the breakdown, he certainly doesn't understand what software is, and that it is integral into the operation of machines. It doesn't. I disagree with the notion that it's abstract per se. It is something what some cognitive computer science calls a liminal object. It exists in the world of design. But so do definitions. All definitions, and patents are definitions, are themselves abstractions. They define something. And so there's really, software is an example of definitions, and what they do is they control the operation of machines. So they're different than music on a piano roll in that sense. And there's many other technologies.
Are they different than punch cards?
Are they different than punch cards?
Which is music on a piano roll?
So punch cards are a way of controlling the machine, but they control the functional operation. A punch roll, to the extent that it is read, right, you could say that controls the operation of the machine, but it doesn't. There's no programmatic control in the same way that software is programmatic control. So I don't think that you can draw analogies, but you can look at any. You can look at printing presses. I mean, when he says that we should be worried about inventions that balkanize online expression, there are patents. What about television, radio, printing presses? All of these patents, would you say, control the various mediums of expressions? I did a quick search between 1920 and 1960, the heyday of radio. The first commercial news broadcast in radio was in the 1920s. There were over 10,000 patents issued. Did that seem to stymie the development of radio and that form of expression? I think not. So I think that there's just lots of fundamental misunderstanding about the nature of technology and how technology creates these conduits of expression, in Mayor's opinion.
Now, you raise an interesting point when you talk about, for example, radio. And one thing I forgot to mention when I introduced you is that, of course, you are a primary evaluator for a ton of technical standards bodies, or excuse me, a ton of technical standards.
That's correct. I'm the primary evaluator for numerous patent pools, including LTE, the LTE patent pool, covering most of the LTE standard, as well as MPEG for audio, so covering codecs for MPEG and Wi-Fi and a number of other things. Do those patents stifle? If you're going to talk about internet patents or software patents, which is, again, he confuses patents on software with patents on communications in the internet. The vast majority of software in the world has nothing to do with the internet. It has nothing to do with the internet at all. It's embedded in our everyday devices that our cars, our ovens, our cameras, most machinery, nothing to do with the internet. So his fixation reflects kind of very consumer orientation. He knows the software he deals with. He doesn't understand the greater world of software and how it plays in technology generally.
But on the balkanization point, do you think that they would play out? Does it make a difference in your mind, for example, if we're looking at a set of technology or a set of patents that pertain to a patent pool where there is going to be access? So in the context of radio, for example, obviously it didn't stymie the development, and that technology was available. But in the case of Intellectual Ventures versus Symantec, we're looking at a single actor who supposedly would then end up with the power to control, any manner of,
virus scanning,
yes,
or email analysis.
Yes.
And in the spirit of full disclosure, I wrote that patent. I wrote the patent on what was called Gateway, the email, the post office one. It was actually one of my finer works, I thought, at the time. So you could say I have a vested interest, but that would not. Let's assume that it was out there. It was not created by a troll. It was created by a software company. It was actually the company behind Mrs. Field's cookies. They had a software development company. That's why their cookies were the best they were. Long story. But that said, I kid you not. That said, that would not control vast domains of the internet for what the scope of the claims. I wrote it. I know what it covers. So the notion that patents are going to control the conduits of expression, no more so, actually quite less so than patents, say, on telephone switching exchanges, or how traffic flows through a router. You have a patent on routing IP addresses. Now you control, the backbone of the internet. But Mayor doesn't know that. He can't see that.
Something I'm hearing both between Dan and Bob, you guys have both mentioned this idea of, for example, printing press or other technologies that have been patented or had patents on them in the past, in the present, that pertain to communication. And so you kind of have this hypothetical, like, what if the printing press were invented today? And of course, that would have a pretty substantial impact on our ability to disseminate what we consider to be a basic tenet and communication channel of speech, printed materials. Is this just a matter of the technology becoming more standard and widespread in a faster timetable than it may have in the past? Because obviously the printing press was developed a long time ago, but it wasn't in the nearly as widespread use until far later, right? I'm seeing shaking heads and I'm seeing confused looks.
Well, I'll jump in here because I do think that one of the issues that Mayor is referring to and that we see as we look around is the increasing divergence between the patent process and the speed of software development. I think patents are not consistent with the way software is made, and we, as a result, end up with a thicket of patents potentially applicable to lots of the components of our technology. We also are seeing many more patents impinging on individual activities as more and more of our communications are mediated by technology, as we use the internet for speech that we might previously have made face-to-face or through the postal service or even through telephone over long periods of time. We're increasingly adopting the latest and greatest of messaging platforms and moving from email to Facebook to Signal and WhatsApp to video and voice calls, each of which requires a lot of technology to connect us, when the bulk of the value of that communication is the network of other people that we're able to talk to. But there are an awful lot of technology providers along the way who might, if given the chance and the opportunity through patent, exercise hold up on those communications and try to extract some of the value there. So I think as we're seeing lots more places that patents could interfere with our communications, we need to be proactive in thinking about the effect that has on our ability to speak equally. And I'm also not saying that every patent implicates the First Amendment, but it is more and more possible that our communications and the freedom of expression and association will be affected by patent monopolies.
So what I'd say is this is no different than any other form of technology. It's no different. The speed issue or the pervasiveness issue is no different than it was the telegraph. Go back to the telegraph, right? You had control. There was a huge amount of patenting around it. In fact, the Supreme Court has actually dealt with speech and the regulation of speech in the patent domain. It did so over 100 years ago in the telephone cases, and it didn't seem to have any worry. It may be that electricity cannot be used at all for the transmission speed, except in the way that Bell discovered, and therefore practically gives him exclusive right for that purpose. Sounds pretty grave and ominous, but that does not make his claim for the use of electricity distinct from the particular processes for which it's connected with this patent. It will, if true, show more clearly the great importance of discovery, but it will not invalidate his patent. Not a concern about the First Amendment, which I believe was in effect back then as well. So these are, what you say is true, but it's true about every form of technology. It's true about telephones. That was the great medium of communication, and patents. Remember, AT&T had the monopoly. You couldn't get on a phone without going through AT&T's network. So, but that didn't seem to be a bother then. Television the same way. So yes, we can talk about free speech and whatnot, but I believe that conflates it with the idea that just because there are patents on the technology, it is controlling speech. The First Amendment is about the content of speech, not the physical mechanisms of speech.
Really wrong. That's absolutely wrong.
Okay, good.
So,
I throw it out there. Shoot down.
I mean, we have Supreme Court cases about newspaper racks, right? We have Supreme Court cases about other types of technologies that facilitate speech. Now, I
can't get a patent on a newspaper rack?
Sure you can, right? So, I would answer your question a little bit differently, right? Which is, yes, it's clearly the case, number one, that patenting is a form of government regulation. Mark Lemley's written very persuasively on patents and the administrative state. Number two, it's very clear that certain types of technologies facilitate or impede speech, right? We mentioned a bunch of them: the telegraph, radio technology, printing presses, and so on. When the government issues patents on those technologies, which it has done, as you said, for scores and hundreds of years, it is regulating speech. That doesn't mean that you can't do that.
No,
right? The only question is, what level of scrutiny do you get? And we already know that the software, for example, gets a relatively low, relatively generous level of scrutiny under the O'Brien test. Right? I think it's very easy for the government to satisfy the analysis and say, yes, patents on radio, patents on telegraph, patents on a new printing press or word processor actually will facilitate speech. There's good governmental reasons why we're doing this. The First Amendment requirement is satisfied, and no problem, as you say, with issuing patents on those technologies. Now, there may be other issues at the other end of my spectrum, not the ones we've been talking about so far, where you get a higher level of scrutiny and you might get a different outcome. Right? But there's no conflict or incompatibility between the idea that certain technologies are covered by the First Amendment and the government can issue patents on them because the First Amendment's scrutiny standard is satisfied.
So I take issue, and I think you beg the question when you use the word regulate, that these patents regulate speech. That's where I think you slid from one end of the argument to the other. A patent on a mouse or on a newspaper rack doesn't regulate speech itself. That patent is on that thing. It regulates the manufacture, use, or sale of that. That's what it regulates, but that's not regulating the speech itself. So I just don't buy that argument. So here's a patent on a bolt, right? You can go down, let's say I invented this bolt. This is actually from the 1972. And let's say the guy who invented this he didn't build it, he just invented it. Now Mark is a famous artist, he paid for thousands of dollars for his art, and Mark says, hey, I'm gonna go make a big old thing like this, a bolt, and I'm gonna call it Screw You, and I'm gonna sell thousands of them. And people buy it, and I go and I sue Mark and say, you're infringing my patent. Mark says, oh, this is art, this is speech. My physical thing is speech, you can't do that. I think we would find that argument, well, in my view, I think the argument would be absurd that his making of something as an artwork cannot be an infringement of the patent because and my patent is in fact ineligible subject matter because it's...
But the question isn't whether it's not an infringement of the patent.
Then what is it?
It can be an infringement of the patent and still satisfy the First Amendment. The question is what level of scrutiny do you apply?
Well, why? The argument would be it'd be ineligible subject matter because it regulates speech.
So to be clear, though, the ineligible subject matter is one proposed approach, right? So that certainly Judge Mayer has taken the position that, hey, we can avoid all these First Amendment problems if we take the tack of saying that this is ineligible subject matter.
Assuming there's First Amendment problems.
Yeah, yes, for any alleged or perceived First Amendment problems. Sure. I always forget that I'm dealing with a bunch of lawyers here.
And what my point would be, if you say that there are First Amendment problems with software, then you have to say that, I think your position maybe is you have to say that with any technology, and then you have to do the First Amendment analysis and say, and you'd find it satisfied.
Yeah, that's right.
Okay.
Which is why,
so that's analytically satisfying. I will say that's analytically satisfying.
Talk about telephone cases, right? I mean, it wasn't before the court, but I am sure that if the court had done the First Amendment analysis, I don't know exactly what the level of jurisprudence was at the particular time for the First Amendment. If you applied, current standards of scrutiny into the First Amendment, I think there would clearly be no problem with issuing a patent to Alexander Graham Bell or other inventors on the telephone that all of the First Amendment requirements would be satisfied, right?
If you want to take, I don't see how you could do it if it says that there would be no other way that his electricity cannot be used for the transmission of speech except by the way he discovered. He preempts the field. And that would satisfy the First Amendment
Sure. I mean, we already know this is true in the copyright area, right? We know that copyright is regulation of speech. We have cases that say that. We know that copyright furthers speech according to the Supreme Court, that you're better off in the long term.
There's a difference, though. We're not talking about copyright law as an instrument and a policy. We're talking about a copyright. The equivalent would be a copyright on a particular thing. The patent is a patent on a particular thing.
And the copyright is a copyright on a particular work of expressive authorship. Right? And the Supreme Court says that's fine. Right? You can have copyrights, and they further speech, and they satisfy the First Amendment most of the time. There might be a limiting case where it's a problem. And so there's no reason they can't coexist. I mean, if I wanted to be a real hard ass, I would just say, look, the way that we normally read the Constitution, right, is that later amendments overrule earlier parts of the Constitution. Article 1, Section 8, Clause 8 came historically before the First Amendment. First Amendment, wipe that out. You can't have patents at all, right? That clearly is not right.
Always inferior.
Yeah.
So on this spectrum that we've identified here, obviously right now we've been primarily focusing on, I think, what Judge Mayer is primarily focused on, which is the access piece, basically. What technology that is somehow fundamental or essential or just very, very important and crucial to communications channels, or what he calls essential tools of communication and research. So one observation I have, Bob, is that with the telephone case, obviously, again, kind of going back to is this about time? Is this about how long it takes for technology to set in? If the court were to look at the telephone technology in a situation where it has already become completely ingrained in society, and such that people realistically could no longer function in terms of a free First Amendment communicating society, would that somehow be different than early on when the technology is nascent, just developed, just patented, and they're saying, well, it may be the only way, but today it's not a standard, it's not essential to communication. And so it's okay to grant, is it okay to grant a monopoly before it has become essential?
So here's the real problem. We are really, really bad at predicting the future, okay? Put yourself, we're all law students, right? So we all know about the Rawlsian veil. Put yourself behind the veil, and you don't know ex ante what's gonna happen. You don't know what technologies are going to be important or not. If you take Mayor's position that it's per se ineligible, how do you know ex ante that that the internet would be this thing? How did you know that Vinsurf and then Berners-Lee, when he invented the HTTP protocol, this would have been the thing? It could have gone down in flames. You don't know. So ex ante, you can't say what technologies are going to be important. And then that would mean, so you allow these patents to begin to issue, and then at some point in time, you flip the switch and say, no longer eligible subject matter. Who decides? What is the standard? What would be the rules? And then you get into, now you're getting into Fourth Amendment, takings or Fifth Amendment takings and whatnot. So that's, I don't think you can say it would be ingrained. Second, it actually doesn't work out that way, because once the technology is so firmly embedded, no individual, because patents are documents in time and they have to be novel and non-obvious, there is no patent today that's going to come out that is going to control the internet, right? They will by definition have to be narrower and more prescribed, and thereby not in order to be novel and non-obvious. So the more the technology gets entrenched, the less likely any one patent or even a small suite of them will control the fundamental conduits of communication. So the development, the way technology development itself solves that alleged problem.
So I think your question is interesting for a different reason, because I don't know which way it cuts. So I made passing reference before to the Red Lion broadcast line of cases. Right? And so if we take your hypothetical, it's okay, someone has developed, Robert notwithstanding, some fundamental technology that we all need to communicate. We have a line of cases dealing with spectrum, which is a public good, right? And the Supreme Court says that the First Amendment is satisfied that the government can regulate spectrum, right? That they can assign spectrum to radio stations, they can assign spectrum to particular purchasers and users, because that's in the public interest. We need someone to sort of coordinate this. We need someone to make sure it's used the best way that it possibly can be used. And the state is permitted, consistent with the First Amendment, to step in and do that in those areas. Well, patents are intended to deal with public goods, right? With ideas and inventions that have the qualities of public goods. And I can imagine a very similar Supreme Court analysis, right, that might say, look, we have this fundamental technology that you're positing, and that Judge Mayer is positing, that is essential to people being able to communicate, and the government is allowed to regulate that. The government has decided, the state has decided that patents are the way to promote that technology, to get investment in that technology, and that may very well be consistent with the First Amendment, under the Red Lion line of cases, because we want someone to develop this technology, and it won't be well developed, or it'll be not used in the public interest if we don't do it this way. Right? So it may be you actually turn your hypothetical the other direction, right? At least under that line of cases. And I don't know anyone who's done this analysis. Right? and say, actually, maybe there's Supreme Court First Amendment precedent that says patents are a good thing in this public goods space.
I agree with that.
But
I'll
wait-
switch sides and say I'll buy that argument. I think that's a perfectly rational
And again,
argument.
it's not that the First Amendment doesn't apply, right? You have to do the
It
First Amendment
satisfies the
analysis.
scrutiny, and I think that's a perfectly rational argument, and better than this one.
And I hope that our ACLU expert's going to say something about speech here in a minute, right? Whether it's broadcast or Spectrum or Red Line or whatever.
I wanted to actually shift a little bit because, number one, that's very interesting. It actually reminds me a great deal of how the exclusivity period on pharmaceuticals coexists with the patent exclusivity at the same time, right? Because there's a separate regulation, a separate set of public interests that lie behind drug approvals and applications.
That's probably unconstitutional, but it's a different panel.
No, that's perfectly constitutional.
But on the other side of the spectrum that we've been talking about so far, like I said, moving from access, we're talking about the actual subject matter where the claims themselves either somehow directly try to, are somehow directly tied to speech or what speakers might do, or in the case of the ACLU's argument that somehow they were a fundamental knowledge going more towards the fundamental section 101. And so I'm curious, Sandra, I would love to hear your take on this. How is it different in the context of genes than the case of access or tools that we've been talking about so far? That one, I know that from the Myriad brief that the ACLU filed, they framed that as primarily an issue of access to fundamental knowledge.
Sure. Hi, everyone, and I appreciate being able to join remotely. Yeah, I definitely want to flag that issue. I think part of what has driven the ACLU's involvement in patent issues is our concern under the First Amendment, not just about communication and speech per se, but freedom of inquiry and thought. And obviously those are antecedents to speech. And I think that's really driven a lot of the thinking we've done in this arena. Back when Bilski was before the Federal Circuit, that was actually the first patent brief that the ACLU ever filed as an amicus, or in any case. And then, of course, we brought the gene patent case. And there, our First Amendment argument was framed around both the method claims that were challenged in that case, which were claims about comparing genetic sequences, which we argued was a mental process, or could be a mental process given the framing of those claims, and thus were violative of the First Amendment from the perspective of claiming thought. And then we were also concerned in the isolated DNA context with the problem of having patents on isolated DNA then preventing any other types of work being done on those isolated genes, which in the case that we brought involved the BRCA1 and BRCA2 genes as a whole, as well as any small segments of those genes. And I think to some extent it ties a little bit to the discussion you all have been having on software, in that in our subsequent briefing that we've done on this issue in Alice and in Mayo, we've been concerned with patents that are so broadly drawn that they in essence prevent others from creating or inquiring about the patented subject matter. So in a software context, you might think about claims where it's just software that's functionally defined, and so thus really preventing other developers from thinking about creating software that would solve similar issues, but being prevented by a claim that is broadly drawn in that fashion. So I think for us it's been both. We've been looking at it, I think, primarily actually from a freedom of thought and inquiry perspective, our work thus far. We've not taken the position, broadly speaking, that we're concerned about software patents as a whole, but we think that many of the ones we've looked at raise some of these fundamental problems because of the way they're claimed.
And so you raised a very interesting question, which is basically what's the practical effect in terms of the exclusivity that these patents offer. So the inability for people to explore other lines of inquiry, to do further research or improvement are some of the things that I heard. I think this also kind of goes back a little bit to the narrowness of a lot of the quote-unquote defenses that may have existed at one point or another with regards to patent infringement. And so the one that comes to mind for me is the experimental use defense, which of course is extremely, extremely narrow as it's been applied by the courts. So we've been talking primarily, obviously, about subject matter eligibility as one way to solve some of these problems. But for example, for the problems that you just identified or alluded to, would expanding or revisiting other types of legal doctrines to help to alleviate those problems, or is subject matter eligibility really the only way to go about this?
I think, we seized on Section 101 early on just because we thought the doctrine helped accommodate some of these concerns. But I do think that part of the issue is that patent law doesn't have those same accommodations as other areas of IP law. And so, whether there'd be a reexamination of those issues, whether it's, thinking about analogies to fair use or developing a deeper concept within patent law and the distinction between ideas and, what ends up getting patented. I think those issues feed into some of the First Amendment concerns and could be, potentially addressed outside the Section 101 context. But right now, in terms of doctrine, Section 101 has been a primary way of trying to address some of these concerns.
I'd like to address some of those points. I guess it's possible, but I have yet to see it in the wild, of a patent on software that someone would say, I can't think about this patent because I would infringe the claims. I haven't seen it, and I've been doing this for a while, and I've seen 10,000, 20,000 patents. I think that's a mythical beast, that there would be claims that you couldn't think about the technology without infringing the claims. That sounds interesting, but I'd like to send me a patent number. I'd like to take a look at it, because the notion that thinking about it, again, that kind of mushes together what software is and what the claims to a software, a properly drawn claim. Now, I could imagine a claim that says, looking at this, deciding in your mind if that, and speaking the following words. I could imagine that claim, but that wouldn't be a software claim. That would be something else. But a software claim would not be infringed in any sense by merely thinking about it. That would not be a true software claim. That'd be something, like I say, it would be something else. So show me a software patent that would be allegedly infringed by thinking about it.
Shaw versus Benson.
No, I'll take it back. The claims talked about shift registers and shifting bits. Unless you have a re-entrant shift register in your head, and then we know Dan is not really Dan, right? He's been planted. But unless he has a re-entrant shift register in his head, then he can't be that claim.
Yeah, but you'll have to duke it out with the Supreme Court on that, right?
Because they got it wrong.
Okay.
I mean, and I'm not the first, nor will I be the last, to say they got it wrong. And they got it wrong for a number of fundamental reasons, not only one of which is the Solicitor General misled them in many different ways. But so what they said and what the reality of the situation are two different things.
If I could add a little bit more detail to your hypothetical, though, the practice of software development, especially of software development in contexts like standards work, where you have a bunch of people working together trying to experiment with something and make things work together. The practice is, in fact, that it's dangerous to look at software patents or to look at patents in general,
but
because the next step from thinking, the making anything concrete, even without having been shown anything concrete in the patent itself, leads to the possibility of an accusation that you're infringing the patent and doing so willfully because you read somebody else's abstract description.
That's true of any patent. It's not any more true of software patents than it is of any other patent. Here's the patent claims for a bolt. It goes, all patent claims are definitions. All definitions are abstractions. You go from the representation, the abstraction, which is the claim, to the thing itself. It's no more true of software than it is of any other thing. This patent claim for a bolt, you think about it, you design it, and then you make it. It's the same thing with software.
But I'm encouraging us to think a little bit more about how software is made in the world, and I think the practices around software development differ in significant ways from a lot of the practices of bolt development. Now, admittedly, I haven't been into a lot of bolt manufacture facilities, but I worked with software developers who are developing code in public repositories, private repositories, trading snippets back and forth.
Well, actually, making bolts today is the same as making software. Everything is CAD, right? And so it's, you program the definition of this, and then it controls a machine which mills it. And so designing this bolt today is no different in essence than designing an electronic circuit, which is no different than designing software. And that leads to another problem with the argument, is that if you say that software is ineligible because of the principle of co-design, all software is coextensively equivalent to hardware. So you would have to say, well, then making hardware is ineligible per se. There is no coherent way to draw the line between hardware and software. In fact, most hardware today starts out as software. It's built in register transfer language, and then so it's the whole EDA process. So you design it in software, and then through a series of what are essentially compilers, it gets turned into a hardware description.
Which is exactly what we've been fighting over for 40 years in the copyright law.
Yes, and that's why copyright failed, in part. I mean, Mayor's view that, oh, copyright is fine. Remember, the reason software patents became the solution is because software failed to protect software technology. Copyrights failed to protect software adequately. That was the whole problem. The whole structure sequence organization did not work. Lotus and Borland didn't work. So the next best, because people wanted protection for software and copyright couldn't do it, so patents became the new mechanism. Why? Because software expresses functionality and patents protect function and structure. It's actually a perfect pairing.
So I will say, though, I mean, just as a reminder, though, although Judge Mayer obviously does make the point that, oh, this is somehow directed particularly at software, I don't think, well, I'm not sure, Wendy, it didn't sound like your points were necessarily, obviously you primarily work in software these days, but it didn't sound like the analysis of patents necessarily was only directed towards software patents, in the sense that
software patents is where the problem is, right? Or where the problem is most obvious, right?
There's a notable problem in software
for
patents.
exactly the reason that Robert is indicating, right? Which is, on the one hand, you have code, which the courts have held is expressive, and which the courts have held is covered by the First Amendment, and that is equivalent to hardware, which is clearly patentable, and which, if it's regulated by the First Amendment, gets fairly low level of scrutiny. As I said before, it gets O'Brien level scrutiny. Right?
Yeah.
But because you flip back and forth between those, you're continually going to have expression First Amendment problems that the patent system has never dealt with.
Yeah. But many of the examples that we've been talking about today are, so the printing press, the telephone, all of these are, we're not dealing with software, we're talking about
that's on the
way
one
that patents get
That's on the one
affected.
fundamental knowledge, though. Let's go. I think we missed the bit about fundamental knowledge, right? Because there was that. I again think that's somewhat of a red herring. All patents cover knowledge. A patent in a chemical engineering process, a patent for an alloy for a new metal, a patent for a new compound, all of these are knowledge. So to distinguish, we get all queasy when it has to do with human biology. Go figure. But it's not any different from a scientific point of view. And in Lynn, Bryson's pointed out, biology derives to chemistry. There's not anything significantly different from a chemical point of view, from DNA, from anything else. It's just a chemical structure. Now we feel very special about our DNA, mind you, but it's not from a physical point of view different than any other thing. And so the notion that it's, and I think this notion that it's fundamental knowledge, it's no more fundamental than any other kind of knowledge, and yet we don't seem to have a problem with patents on chemical processes or on compounds or on medications. It's all fundamental knowledge.
If I could pose one potential difference that I'm curious to get your take on. So you mentioned alloys, and one area that I'm also familiar with is comparing it to encryption. So with an alloy, you yes, it may be chemical, and it may be defined by a process or a method for creating the alloy. It also may be defined by the characteristics of the alloy itself, right? But at the end of the day, you can acquire that alloy without yourself infringing the patent. So, for example, if an authorized person is creating the alloy, you can buy that alloy in bulk, and then you can go ahead with your experimentation, your research. You can forge it into something new, and you can do things with it.
Okay. Same
But
thing
when
with
we're
any
talking
software patent.
But when we're talking about knowledge, so you don't have the ability to acquire the knowledge in a licensed and authorized way. So if you are a researcher,
I go to you and I get I go to RSA, I get the license to the RSA patents. So same thing. What's the difference? What do you say? You don't have the ability to acquire it? Absolutely do.
So I'm going to agree with Robert, but for a different reason. Right? I agree that the knowledge question is something of a red herring, because there is no question that the government can regulate scientific inquiry. Right? If it is dangerous, right? If it is socially counterproductive.
Yeah, marijuana. Can't study that.
Well, there are certain types of nuclear physics that can only be studied at certain places, right? At Lawrence Livermore, or because you can't get the materials, right?
Paul, I gotta go because my garage is.
So the idea that the government might regulate that through patenting is not in and of itself a problem. You pose the encryption example, right? There is no question, right? There is no question the government can regulate encryption. Now, there is a First Amendment question.
I wouldn't say there's no question that the government can regulate.
Well, secrecy,
but they have done
secrecy orders in the
for
past.
quite some time.
I mean, the courts have come back repeatedly and said this is permissible, and yes, there is a First Amendment analysis that needs to be done. But as long as the government stays within the First Amendment boundaries, you can have government regulation consistent with the First Amendment and consistent with public safety and security.
Well, let's just go right to the heart. In the patent system, you have secrecy orders, right? You cannot publish this patent. This patent cannot issue, i.e., the knowledge cannot be shared. Forget the claims, right? It's not even a matter of whether the claims are. This information, which was, the quid pro quo disclosure invention of the public, it can't even be published. There are secrecy orders still in place for patents filed during World War II.
So there is nothing fundamentally unconstitutional about government regulation of scientific inquiry. Right? Now, as long as they do it within the bounds of the First Amendment, and then the question is, what level of scrutiny do you apply, and does the government pass that? Right? So patenting per se, with regard to scientific inquiry, isn't going to be a problem from the First Amendment standpoint, as long as you pass the right level of scrutiny.
So when you're looking at a specific patent, though,
I'd like to hear how Sandra responds to that.
oh, okay.
Sandra?
Sandra, are you still with us, or?
I'm sorry, you cut out a little bit at the end there. So it seems like you are waving. So I'm wondering if people are talking to me.
I was pointing out to Robert that, and to Elvin, that it's clear that the government can regulate scientific inquiry, right? It does so with regard to fissile materials. It does so with regard to certain types of biological materials. So that in itself is not the problem. The only question is whether the government does so consistent with the level of scrutiny, First Amendment scrutiny that's required. It's not off the table. It's not unconstitutional, as long as the government does it within the proper bounds. Right? And one of the examples we were talking about was encryption.
Right. Yeah, I mean, I think that's right. I think that the issue from my perspective is that too often, the governmental interest that's given or assumed, I guess, is that, the patent system encourages innovation, et cetera, and that may be the interest that's given for any particular patent. I think it makes sense when you're talking about, if you're looking at specific patents that raise First Amendment concerns, if you're going to do the analysis, you really need to look at what the governmental interest is for that patent, and it should not be just a generic interest in, spurring innovation or the general rationales for the patent system. And so that's where I think, that component of the analysis has generally been missing.
So, you laughed at me, or with me, one of somebody at me, maybe, when I did this. Why? Why did you think it was funny? Because I confused the representation of the thing, you, with the real thing. Right? No, but seriously, this is important. I confused the representation. I treated the representation as if it was real. If you think that is funny, then you should laugh at Mayer as well, because he confuses the representation of the thing, patent claims, and software with the thing itself. He makes the same kind of cognitive error that I intentionally made. And so if one is humorous, then so is the other. And it shows the fallacy. There's a fallacy in my thinking there. There was a fallacy in his thinking there. Software is not this, we say, oh, it's software is expression. A court has ruled software is expression. Okay, well, that's the end of the matter because courts have ruled on it. I don't buy that. I buy what's scientifically correct and true, not what courts think about things as a matter. So that's because I'm a practitioner. So that courts have said it's expression doesn't make it expression in a real, in any meaning, in my view, in any meaningful. Yes, I can put comments in code, and that can be funny, or I can, be elegant in my drafting of code of an algorithm, make it really tight and whatnot. So you could say that's expression as much as this bolt is expression, but then everything becomes expression.
Can you read source code?
And yes, I can read source code, but
And it's clearly expressive.
But source code doesn't. You have to get from source code to object code before you execute in a computer.
Yeah,
Okay.
That's right. And so the question is, can you separate, source code
That
from
I
object
can read it,
code?
but okay. So then, I would push back and say that I can read it doesn't make it expression. Why is it expression? Okay. Why is it expression if I can read it?
See, I'm fascinated, Robert. You say lots of things that aren't the law.
Well, I've always been doing that. That's nothing new. Your hobby hasn't. People have been complaining and telling me from the very beginning I started practicing. Says that's not the law is. That's what you want it to be. I said, well, I know that.
Well, we can have kind of a free-form discussion about what we'd like the law to be.
I thought that's what law professors get to do, though.
We tend to start with some basis in reality.
Okay. I know what the law is, and I'll tell you, yes, I know what the law is, but it also could be wrong.
Yeah, well, it could be, right? And it might change, but that's why we start saying things like, we have rulings on this, we don't have rulings on that, and so we start with what we know,
Sure.
or what the case is, and then we can move towards.
But there's a real.
things.
This is if you want to talk about legal.
So going back to your question, if you can read it,
yeah,
it is expressive for First Amendment purposes. Full stop. We can talk about a different world.
Okay, we'll take that as an axiom.
Yeah.
Okay,
we can talk about a different world where that's not the law, but that's the law as it stands right now.
Okay, fine. I'll admit I'm not a copyright lawyer.
And there are people who in limited cases can read some object code, right? It's hard to do.
Yeah.
It's annoying to work with it that way, right? That's why we have higher level source code.
Exactly.
But again, if it is can be read by an engineer, it's expressive to some degree, and there's going to be a First Amendment issue. Now, again, the question is, what's the level of scrutiny? Going back to what Sandra was saying, if all you have is rational basis scrutiny, then the government's saying, oh, well, this promotes progress of science and the useful arts, so we have patents. That's enough. That's plenty. If you're going to ratchet that scrutiny up, then they're going to have to come up with more evidence.
And I'm fine with it. I think the analysis makes perfect sense, and I agree with that.
Yeah, and I think one of the other changes that we see with the proliferation of software patents is less weight on that incentive side. So if we granted that the purpose of patents to promote progress of useful arts by granting an incentive to the creation of those useful things, we see that working less effectively in software development than it worked in mechanical development, because the distance between the abstract idea that is patentable and the implemented code that functions is far enough that somebody gets the patent well before he or she has produced any functional, useful code in the world. Often, gets the patent and uses it only as a weapon against those who have produced the useful functional code.
I completely disagree with that. That's a nice story, but most of my clients, they make the stuff, and they make it. In fact, they are often hesitant about filing before they have something actually in production, that they have code that actually works. Yes, there are people who do armchair software, armed to prevent. That's certainly possible. That's the rules of the game, by the way. That's perfectly acceptable. But the vast majority are not people who haven't invented anything, haven't developed any code, and are just doing it for the heck of it to go after other companies. I think, I'm sorry, but I think that's a fiction. Those are not the companies that I've ever represented.
Well, I'm glad you're representing the good guys, and I'm glad that the guys you're representing further succeed with producing enough to hire good counsel and to litigate their patents
but that's
effectively.
The majority. It's not just me.
There are also lots of companies who may produce a product that's inferior, go out of business, and leave their patents hanging to be used as weapons against others or to be sold off. There are lots of ways that patents have effect beyond the stimulating the creation of great and useful software.
But
I think that changes the balance,
with incentives.
especially when we have the First Amendment on the other side.
But you started with incentives. You said that the incentives don't work. In fact, your argument would go exactly the other way if the idea was that you could patent software without doing the hard work, so to speak, of doing the software. That's actually a more of incentive to patent. Think about it. If I can get a patent just by kind of putting some stuff down and I don't have to do the work, now I'm really incentive because I don't have to do all that hard work. If patents were limited to, I had to build the thing, and it's like, oh, it's too much trouble, I'm not going to patent that. So if what you said was true, we should see more of this than less of it.
And I'm not sure how that contradicts the world we're in, where we do see an awful lot
What
of
I'm also saying is, you're suggestive that if I understand you correctly, somehow that it's not facilitating. I'm not sure where it was going with this, but it's certainly not impeding. Well, I would say we don't have a lack of innovation because there are too many patents, and we'll leave the.
How do you know that?
Well, how do you know that, right?
We don't.
I guess because I can go out and buy a new cell phone every 6 months or every 3 months.
I mean, read Lemley's last article, right? Yeah. I mean, we are getting a larger and larger body of empirical evidence that suggests that patents either don't promote innovation, or maybe they're impeding innovation. But at this point, we don't know. So it's a religion.
Well, okay.
Well, it's an article.
It's unclear, right? Unclear, but we do know that if we seem to have more innovation, software otherwise, in this country with probably the most liberal of patent systems, and countries that have no patent system or very restrictive ones have less. There's also evidence that goes that way.
So I don't disagree with Wendy, except I don't think it's a constitutional problem, like what you're expressing, right? I mean, it's a policy problem, but I don't know that the fact that patents aren't working or might not be working the way that the government says that they are means that it's unconstitutional.
Right?
Just like the fact that I'm not sure that various other types of regulation may or may not be working the way the government wanted them to, means that they're unconstitutional.
And I think it enters the rational basis scrutiny of, is the government regulation doing a good job against other interests that are expressed in this system?
Yeah, that's going to be higher than rational basis, right? As a rational basis, you say,
we
thought it was going to do this, and you're done, right?
But that issue about the promotion of science and whatnot, Judge Rich, the guy who wrote the act, who knew what he was talking about, he addressed this actually in the Kettering lecture that he gave, where he talked about it's not about any individual patent. It's a policy decision embedded in the patent law itself. Congress has made that policy decision that a patent system does in fact promote the progress of science and research. You don't apply that to any field of technology. It's the patent system itself that satisfies that level of inquiry. So that particular issue has been addressed. And again, and the other point is, you can't bring it down to an individual patent. Some people say, oh, well, that patent is unconstitutional because it doesn't promote. Again, you can't know ex ante or even ex post facto which patents are the ones that promote. Most if you Google technological prediction failures, you'll get lists of things that, like, the television will have no practical use, or why do we need telephones? We have office boys, right? There's plenty of evidence that people cannot predict the future of technology, so there's no way to know ex ante, or even holding this patent in your hand, whether this is going to be important to technology or not. So you can't apply the test at an individual level.
Circling back to your question.
Yeah, but I will point out, so the question here today, though, isn't necessarily whether or not a particular patent even, I mean, assuming we're even going to look at a particular patent, it's not about whether or not it will promote innovation or other forms of technology. It's about whether or not it will restrict speech. And courts do regularly look at, for example, statutes in the abstract and say, like, even though we're only looking at the one case today, it looks overbroad to me, and it will impermissibly restrict speech. And so that is a practice that is regularly engaged in by courts. But Wendy, I would love to hear a little bit more, because obviously you are in the room when a lot of these, the companies that you work with through the W3C do encounter the specter of patent infringement. And so you have kind of a front row seat to what the actual impact and reaction is. And related to that is another issue that I'm hoping to also get your input on, which is this part of the spectrum that we haven't touched on today, which yet, although it was in your article, Dan, which is about indirect liability and things like willfulness, which are kind of, in some sense, more directly tied to speech than perhaps just the claims themselves, right? Because they're trying to basically say that you have liability, or you can be held liable because you provided the instructions for how to assemble this, or you encourage somebody to commit a particular act or assemble a particular object or write a particular program. So I would love to hear either of you guys' kind of perspective on how that actually plays out in the real world, and what's the impact here on secondary liability.
Yeah, thanks, Alvin, and I'll take the opportunity first to sort of say about W3C that most of what I'm saying here is not from the perspective of W3C, but a personal opinion. But I think that W3C has an important policy position in its patent policy in this area, which is that, you know, we operate as a consortium producing standards with the goal of producing standards that can be implemented on a royalty-free basis. And so we implement that by requiring all participants who join in the creation of a standard, which we call recommendations, to commit to all of any essential claims that they might have, any patents that might necessarily be infringed by implementation of the standard on a royalty-free basis, or specifically to disclose and exclude those patents. So coming in, everyone who's participating in the creation of a standard at W3C is saying, we agree to license royalty-free anything that's essential to the creation, implementation of this technology being specified. And that's a way to go from the original vision that Tim Berners-Lee had when he took the original HTML and HTTP work and put this concept of a World Wide Web and the software and technology implementing that concept into the public domain, declined to seek a patent on it, published it so that it would be available royalty-free. And so W3C participants enforce that by, you know, we don't talk about patents in working groups. We talk about technologies. We talk about customer needs and design decisions and effective ways to build the technology. And if someone raises a patent claim, we convene a separate group, a patent advisory group, to work through the questions of, is there an essential claim here? Is it a valid claim? Would it be infringed? Or is there an argument of non-infringement by the specification? Do the authors working on the spec need to do something different to avoid these claims? Do we need to find prior art to help invalidate the patent? What steps can we take to make these technologies available royalty-free? And so patents cause, you know, some cost to the system. Some places that engineers are routinely told don't look at patents form a separate group to look at patents, because we don't want the potential taint of, if this patent were relevant, of having engineers who had looked at that patent before doing their work. And so patents here are doing a pretty poor job, I'd say, of serving as disclosures of useful knowledge to the field more generally. In the case of royalty-free standards, they at least, we found one way of sort of voluntarily disarming.
So that may, I think that is a perfectly appropriate way to deal with, to design the standard. On the other hand, we're all really super happy that we have LTE phones and we can get the internet, from any room in our house. I'll leave it at that. But the point is, if you look at the LTE patents, and I was doing that before I came here this afternoon, a lot of what's in that, the exact technology standard is what is in the patent, and those patents were filed, and then the technology was disclosed to the standards body along with other competing technologies who knew that it was patented under FRAN, and available under FRAN, and they adopted it. So the patent system there worked for disclosure purposes. So it does cut both ways. I mean, and again, these are practical problems. We know the patent system imposes costs. By definition, it has to impose costs. But they're not constitutional issues, right? They're not, nor are they subject matter issues. They are systemic, but they are not, and they're not particular to software. They're true in any area. There's lots of historical research on the patent wars for sewing machines and how patent holdup was applying in the sewing machine industry, in aircraft manufacture. These are not new problems.
And in fact, that cuts the other direction, right? Which is, if I were constructing the argument, for example, against the historical argument that I made earlier, that the First Amendment obliterates the patent and copyright clause, I would probably point that out, right? I would say, as the Supreme Court has said in the copyright area, you can certainly say in the patent area that this encourages disclosure, right? To keep people from hiding information or keeping it as a trade secret. And so you have at least a rational basis for the government to promote.
And that's the policy.
That's part of the policy.
And so I think that's where this circles around. Whatever decision is made here, so to speak, it's not the court's job to do this. To say, oh, Mayor, I'm going to say all software is ineligible because I believe X. That's Congress's policy decision to make. Wow. And the Supreme Court itself has said that. They said it in Bilski. They said, we hold no opinion as to whether this should be eligible, software should be patentable. So the Supreme Court itself, quite contrary to whatever draft of Alice Mayer wrote, has not taken that position.
I think Mayer is saying something a little bit different. Right? So if you are willing to view the facts in the light most favorable to the judge.
Okay.
That's a new standard.
Let me hear that one, counselor.
Yeah,
Moving for your client. Go ahead.
If he is saying something like, I believe that there is a First Amendment issue with software, such that software, anytime you try to patent it, you're going to violate the First Amendment. That is very much the court's job, right? To say that, right? If he is saying, that as a practical matter, Alice is going to eviscerate software patents. I actually know quite a number of practitioners who believe that has occurred, right? That Alice has become a problem, so that you can't get software patents. So there are a number of ways to read that somewhat differently than you have. I want to get back to your secondary liability question, right? It's not that we can't have secondary liability consistent with the First Amendment, right? We know that there are lots of kinds of speech where if I engage in it, I may be secondarily, criminally, or civilly liable, right? If I advise you on how to commit tax fraud, right, I am going to be an accessory. I'm going to be in trouble. If I advise you on bomb making, I am going to be in trouble, right? If I advise you on certain other types of illegal activities, I may have criminal or civil liability. But the standard there is higher for the government to meet, right? Because they're placing a burden on what would otherwise be perfectly constitutional protected speech, right? And we've never done that analysis with regard to secondary liability, right? So if I,
as far as I know,
yeah, as far as I know either, if I take Rob Merges's sort of famous example, right? I'm going to give you a kit, right, that has all of the parts to infringe somebody's patent, and then I will also hand you the patent, right, which discloses how to make and use the invention. I may be a contributory infringer. or I may be inducing by virtue of having given you a publicly available document in conjunction with some other activity. It's not that that can't be infringement or that the government can't regulate that, but we need to ask what's the proper level of scrutiny and does the patent system actually meet that before we can answer some of the questions that the Supreme Court and the Federal Circuit have been struggling with about inducement, for example. Recently.
Yeah. With the W3C, I think is a particularly interesting example because, like a lot of other standard bodies, they typically aren't themselves writing software, right? They're setting standards, and so they're writing specifications that are instructing others on how they should write their standards. So obviously, Wendy, you pointed out that the primary concern around patents is making sure that it's free for everyone to implement. But is there ever, or has there ever been a concern, and knock on wood here, that merely by publishing a specification that somehow that could give rise to liability? Granted, W3C probably not deep pockets, but but is that of a concern? Because I think that really kind of goes to this type of inducement question, a pure inducement type of scenario that you're talking about. Or has anyone been afraid to participate in a standard setting process or a working group because of a concern around those lines? I know that obviously maybe
and remember
you can't.
that the Fifth Amendment allows you to not incriminate yourself. But
In the case of a hypothetical standard,
Yeah,
Cody, I
There's
could
no
certainly
charges.
imagine.
There are no charges here, right?
I think that there are places where interpretations of patents restrictions chill participation in all sorts of strange ways. There are strange and not so strange ways. I mean, there are certainly companies, participants who have sort of varying degrees of vetting processes before allowing people to participate in working groups, whether it's because they're concerned that they would imperil a patent of which they don't know that they own and want to monetize later, or that they might be exposed to something in the participation of an activity that could later be accused of infringing a patent. It is the patent system is certainly adding burden to the process of producing standards for interoperability. Our goal is to enable people to work with the same language across devices and operating systems and continents, and the process of specifying what those interfaces are should be one that's freely available, without cost and without sort of additional licenses or hurdles to clear before implementation. So I don't think we've, certainly not in my time, been implicated directly in an infringement. A few times, various of the inventors of web technologies who work with W3C have testified against patents that are, alleged around, closely related technologies. But so far, the core of the web has been available royalty free.
Yeah, I don't think that. I've been doing standards evaluations for 14 years. I've evaluated several thousand patents, and I've been in communication with SSOs. I have never heard of a company going after an SSO, standard setting organization, on a basis of contributory liability for publishing a standard. I mean, you could think about it, but I don't know of any instance, particularly since I'm looking at patents that in fact cover the standard, that would be a prime candidate. Someone would say this patent covers covers that implementation of that function in that standard. IEEE is liable. I've never heard of it happening.
But the fact that we are discussing this, right, and that it is being streamed live.
Never know. Side effects.
Just win.
Yeah,
I promise you. I promise you it will happen.
It's certainly been the case where
there is only one
somewhere
law.
out there there's an attorney going,
No,
whoa.
there is only one law that
Light bulb.
governs human affairs. It's the law of unintended consequences.
So I'll open it up for questions in just a moment in case people have, so please feel free to come up to the mics. Quickly, before we move it to questions, quick survey of our panelists here. What should be done, if anything, I'm pretty sure I know what Bob's answer is going to be, so maybe we start. But does the First Amendment, does speech need to be addressed in the context of patents, and if so, any idea what it should be?
Yeah, I like your analysis. I think that's cogent. It's rational. Should it be applied in the case of any individual patent? No, I don't think that it would make sense in the case of any individual patent. I think, as evidenced by the failure of the courts, as I see it, to understand what Section 101 is about to begin with. And again, I think we're talking about a 101 issue. They are no more competent to address the nature of 101 in terms of technology than they would be in this. So I don't think it should. I think there's already been a policy decision made. Okay. And if it is to be made any further, it's Congress's and not the courts.
So Bob's vote is nothing really needed to be done. To the extent that it does, it's already being dealt with, and the courts shouldn't act further on that. Wendy?
I think by and large it's a question for Congress, and would that we could get a Congress that were able to act on the policy problems and the increasing amount of evidence that we're seeing about how the incentive system works. I think that there can be classes not of works where the constitutional problem arises. I don't see them yet.
Anna?
So, Mark Lemley and I wrote a book about policy levers that are exercised by the courts because Congress just isn't ever going to get around to fixing some of these things.
They have their hands full with healthcare and tax reform.
Exactly, right. All those kinds of things that are very important. Clearly, we need some type of fair use in the patent system. Right? That's what saves us in the trademark area. That's what saves us in the copyright system. Increasingly, we're going to have these problems in the patent system, particularly since we don't have, as you said, a strong experimental use doctrine anymore. The printed matter doctrine is kind of withered on the vine. Some of the exceptions in patent law that could do some of this work don't exist. So we need some type of fair use. It would be great if Congress would do that, but I don't expect that to happen anytime soon. So the question is, can the courts do something? Well, fair use was originally in copyright was a common law doctrine that was developed by the courts, but I don't think the courts actually need to. I think they may have already done the job, right? And the Supreme Court has already paved the path to solve this problem, I think, in the eBay case. So I have in the past called copyright fair use a compulsory license that is zero royalty. Now, there's no reason it has to be a zero royalty, right? In order to satisfy the requirements of speech, right, of the First Amendment, you need to have access, but that doesn't mean you have to have free access. Right?
Let's go back to whether or not it being available under RAND terms would somehow make an impact, right?
Exactly. So the balancing test set out by the Supreme Court in eBay tells us, right? You don't always get an injunction. Sometimes you get damages. Sometimes you get an injunction, but we have to look at equitable factors. One of those equitable factors is the public interest. Right? I can see a type of fair use developing, where you say, okay, we have a really serious First Amendment problem here. Somebody needs access to this technology or this software or whatever in order to engage in speech. That is technically an infringement of that patent on the bolt or whatever it is that Robert's been waving around. And the court says, great, so we're going to do the eBay balancing and say that you get access. The patent holder doesn't get a permanent injunction. You're going to have to pay for access in the form of ongoing royalties or other damages. But the public interest embodied in the First Amendment sort of dictates that that's the right outcome. Right? That wouldn't be my preferred outcome, but that's a path that I think is open.
Okay. Sandra, any closing thoughts before we get some folks up here from the audience to ask questions?
Sure. Well, I mean, I think unsurprisingly, we certainly think that the First Amendment is very relevant to how patents should be thought about. And, I think in some ways we've seen our role over the last few years trying to raise that issue in the courts. Certainly, I think that First Amendment issues are decided all the time by the courts in other IP contexts. Up to now, it's been there's been a lot of silence within the patent law arena on this, and so to whatever extent Judge Mayer's decision, I think, opens that conversation, I do think that it would be unwise of the patent bar just to assume that somehow patents are immune from constitutional scrutiny, particularly where we are seeing more patents that are coming up in the public arena that are claiming, that have serious implications in terms of claiming thought and speech. But, you know, I agree that right now the doctrine is, and I think in some ways the tension is arising because the doctrine has been unforgiving on these issues, except under Section 101 and abstract ideas and the exceptions there. There may be enough pressure points that courts start looking to some of these alternative routes, like Dan was suggesting, you know, because we know, at least in the short term, that Congress will likely not act. Thanks.
So I did a poor job as a moderator. We have time for one very quick question if somebody has a pressing.
But it seems to me like you get into even more interesting questions when you're talking about inducement and thinking about, say, medical methods, right? Which since starting October 1st, 96, couldn't be, any patent that was applied for after that couldn't be, you can't get any remedy against a doctor for practicing a medical method. The only theoretical remedy you can get, really, is either inducement or contributory. So the act of teaching someone to perform a medical method that may be life-saving is theoretically an act of inducement, even though you couldn't go after the doctor who's being taught. How does that play in? And I realize that's not a short question at all.
I'll just say this. I am pretty sure that the law, as we have it for inducement and contributory infringement, you know, 271 B and C, will survive constitutional scrutiny most of the time at the right level of constitutional scrutiny. Now, the problem is we've never done that analysis. Right? So if there are any students floating around, there's a good law review note to be written about doing that analysis. But as I said, you know, there are lots of other situations where assisting a doctor to engage in a certain type of procedure is regulated, and you could be criminally or civilly liable for helping a doctor to do that, for instructing a doctor on how to do that. So the fact that instructing someone how to infringe a patent, whether it's a medical procedure or some other type of patent, could be infringement, wouldn't surprise me at all, but you have to do the analysis. You can't do what we've done so far, which is just sort of ignore the level of scrutiny that has to be applied.
Well, again, I apologize for the lack of time for questions, but please join me in saying thank you to our panelists, and again, thank you to Stanford Law School for hosting. We hope you enjoyed the conversation tonight.